and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. I'm continuing my series on deportation processes and what you need to be aware of and what you need to know in order to help yourself should it be necessary in the future, and should you be detained or put into removal proceedings. I want you to know that, as I've stated in prior videos, when Trump's policies go into effect, assuming they do go into effect, you cannot just be thrown out of the country. Okay? If you have been here, you have a right in which to fight your case in immigration court. The U.S. laws, which were made by Congress and signed by the President of the United States in different varying degrees over many years, gives rights and protections to people who are not U.S. citizens. So unlike the comments I've received, which basically state that everybody who's not a U.S. citizen should be kicked out of the country. And unlike the broad-based policy of Trump that millions will be rounded up and deported, the laws of the United States say otherwise. And if you are familiar and know that you can fight your case, that of course will take a lot of fear away from the fact that you think that you'll be driving down the street one day and ICE officials will come put you in handcuffs and throw you out of the country, because that won't happen. So in continuing with the series, uh, once, for example, you get put in detention, which that may very well happen, then you'll be served with what's called a notice to appear. Okay, and the notice to appear is very similar to what would be called an indictment in the criminal arena. So a notice to appear is essentially a document that immigration will serve on you, which begins the deportation process. And the notice to appear is a very important document. It basically says, what your current status is, how you entered the country, when your status expired, if it did, and then it lists the grounds of removability as to why they believe, they being immigration, believes you're removable. This notice to appear is then served on the immigration court, at which point jurisdiction then resides with the immigration court, not with immigration, not with ICE. Okay. And what that means is that no matter what they tell you, they being ICE officials, once the immigration court has been served with the notice to appear, or NTA for short, then they being ICE have lost jurisdiction in which to do anything with you, basically, except keep you detained. However, and this will be on one of my next in series, how to do a bond redetermination hearing, that will go in front of the immigration court. Okay, so with the notice to appear, I could have, the next 10 videos on what and how to properly respond to and do with a notice to appear. But for all intents purposes, if you understand that that document is what starts the immigration removal proceedings in court, and that it transfers jurisdiction of your case to the immigration court, that should give you some relief, knowing that because jurisdiction has been transferred, you then have a right to fight your case, and the case will be fought based on what they allege in the notice to appear. And there's all kinds of ways of fighting a notice to appear. Of some of the allegations are admitted, some are denied, some are go for what's called a contested hearing. But initially, what you also have to realize is that the immigration, okay, they have to show by clear and convincing evidence that you are removable. Okay, so the initial burden of proof to show you're removable is on immigration. It's not on you. You do not have to prove that you're removable or that you're not removable, immigration, has to prove to the immigration court by clear and convincing evidence that you are removable. Now, in the past, for example, if you're in removal proceedings because of crimes, I've had the immigration, they'll list on there, you committed this particular crime and you have this sentence and so forth, but they don't have the conviction documents. They don't have the abstract of judgment. They don't have the docket sheets. They have nothing to prove that you actually committed the crime. And obviously, if I were representing you, then, I never admit to the crime, to the allegation of the crime on the NTA, because that is their job. They have to prove it. Okay, and if they don't, then the case will be terminated. So if immigration is going to serve you with the notice to appear and allege certain crimes, they of course have to have documents to follow and prove it up. Okay, and then of course we go through the various procedures. But that's another thing, as I've stated on prior videos, don't sign anything, because the only thing ICE wants you to sign is something saying you want to voluntarily be deported and not fight your case. By the same means, don't admit to anything either, because there you have rights. And I've had cases where immigration did not provide the evidence, and then the judge turns to the person who they're trying to deport and says, so and so, did you commit this crime? So of course I, object. I state, Fifth Amendment rights of self-incrimination. I state that the judge cannot require the person who they're trying to remove to substantiate and to prove his own removability, because that changes the burden of proof, and it's against the law. Not that judges are happy when I do that, but there's nothing that can be done other than to follow the law and then to request immigration to provide the necessary documents. So I've only touched a little bit on the NTA and, what can be done with it and how it really starts the procedures. Um, but again, for your purposes, two things. Know that the NTA is a good document for you, because it gives the right to fight your case and it lets you know how you're going to fight your case. And secondly, be sure you call an immigration attorney. Okay, because just as you would not commit a crime and want to appear in criminal court by yourself and think that you can maneuver through the maze of criminal procedure, the same is true of immigration. While you do not have a right to have an attorney as you would in criminal court, it's very important. So go ahead, if you like the video, click like, subscribe. You can also give my office a call. I do give one free consultation regardless of where in the country you are, because I do have clients all over that I help, and we'll go from there. And I'll continue with this series on the deportation proceedings. I'll basically, each video in line will describe the next phase, so you'll have a much better idea after you listen to the whole series as to what can be done and why, essentially Trump saying he's going to round up and deport millions is just not going to happen. Okay, more in the coming videos.